Dairy Legal webinar. This is the Center for Ag and Shale Law's regular quarterly series on dairy legal issues. And this is for the second quarter of 2022. In other words, April, May, and June of 2022. Okay. Normally, we have an introductory portion, which we will do today, that is a general overview of recent developments in the dairy legal field. And then we will have a focus topic today of labeling standards for plant-based dairy substitutes. Sort of timely. We will go over where exactly all of that stands. And Chloe Marie, who is one of our staff research specialists, will concentrate on that topic. Wait a minute. There we go. Okay. If you ever want to take a look at any of our past quarterly dairy legal webinars, they are available on our website here. And this tab right here where it says watch or listen over on the right-hand side is where you can take a look at them. And they are all lined up there. So you can just click on there and watch them. Some of them are divided into parts, and also the materials that are used, the PowerPoints, are also available on our website, so you can get all of those. And the same goes for today's session. The PowerPoints will be available. This is our 8th one in this series. Standard agenda, we again go over recent developments, then we have our focus topic, and then we have a question and answer session, hopefully. Many times we do run out. It's probably usually my fault. And don't forget about our website generally. Our website is packed full of all kinds of good things. Take a look at it. It's very easy, aglaw.psu.edu. Couldn't get any simpler than that. I want to thank our partners who help us put together this particular series and help us with funding, which is the National Agricultural Law Center, and ultimately the funding that we receive that helps put this all together comes through the National Agricultural Library at the USDA. And a couple of housekeeping matters. Of course, this webinar is going to be recorded. Please use the question and answer feature for any questions rather than the chat feature. And we, of course, offer CLE credits for Pennsylvania licensed attorneys. There'll be a link for that posted in the chat. Maybe it already is. And please fill out the form today if you can. It's the sooner you do it, the better, because we do have a very strict time limit on those forms and compiling them and sending them in. So do it as soon as we're done here. There will be a code word, which we have to do to ensure some sort of modicum of attendance checking. So our code word will come more or less in the middle of the entire event here. We will put the code word up on the screen, and that's required on the CLE form. If you have questions about your credits or any other aspect of this, this is Jackie Schweiker, one of our other staff attorneys. Emails, and Jackie graciously agrees to do some of that legwork, so she'll field questions if you have any with regard to the webinar today. All right, okay, again, today's agenda is I will go first with a roundup of the past quarter's legal and regulatory developments, and then Chloe Marie will go forward with a really interesting analysis of labeling standards for plant-based dairy, not only in the United States, but also talking about the EU, which is very helpful to sort of compare to what's going on here. And so it gives you something to sort of see another process that they're going through, which is actually more involved or more advanced, I should say, than the US process at this moment in time. However, we do have developments brewing here in the US on these issues. All right, let's get right to the quarterly legal update from April to June. The first thing I do want to alert you to is that the center, on our website, we have what's called virtual resource rooms, which are essentially just resource rooms that have all sorts of resources on a particular subject organized in a certain way that's most conducive to that particular subject. In this last quarter, we went live with a virtual resource room that is called Dairy and Dairy Products Law. You click on this link from the PowerPoint and you can go right to it. We have a full slate. It's certainly the largest and most fully populated virtual resource room that we have. Spent a lot of time on that, putting that whole thing together with the help of Chloe Marie and with the help of a number of our research assistants who are students. And I think you're really going to like it. If you need to do any research in the dairy area, we have all kinds of things in there. So please go check it out. And that, in fact, was a development in this quarter. Let's start with Pennsylvania developments, specifically the Pennsylvania Milk Marketing Board. The Pennsylvania Milk Marketing Board on March 22nd issued the latest in its series of official general orders that extend the current overorder premium in Pennsylvania at $1 per hundredweight for the period between April 1st and September 30th of 2022. And by the way, I do see there's a poll here that just popped up. Please do fill that out. It really does help us understand how we're getting people to attend, as well as depending on what other questions we have in there. Very helpful. So take a second if you can, please, and fill that out for us. So while that particular overorder premium remains in effect, and again, going back, I just double checked to make sure we've been accurate on this. You know, it's been $1 since April of 2019. And in this 6-month period, we are now going to see quite a large development occur here, which is that the board has agreed to conduct hearings on a petition that was filed by the Pennsylvania Department of Agriculture. And those of you who know me know my background. And when I was chief counsel there, we filed a similar petition, but it wasn't nearly as specific as this one. You know, this one is a bit more pointed. You can, of course, get copies of the petition at the links that are indicated here. The board has agreed to schedule hearings, and as soon as we get to the next slide, you'll see the dates and everything for those hearings. This all rises out of the fact that at that last overorder premium hearing that set continued the $1 overorder premium, there were documents submitted on behalf of several witnesses that wanted to have a larger discussion or hinted that they wish to provide testimony on the larger issues of the current administration of the overorder premium as it exists today. There was a bit of a back and forth with regard to whether some of that testimony would be allowed and whether it was beyond the scope of what the hearings had been set up for. But the bottom line is that's all been cured by the fact that this petition now has its own, was filed and now has its own hearings, which are going to commence on August 30th. And the request was that these hearings be held prior to the current overorder premium's expiration date of September 30, I think it was. And so these will start on August 30, and they will essentially continue from day to day as needed, wrapping up on September 1, if in fact the 3 days worth, August 30, August 31, and September 1 are needed. And this is again to adjudicate this May 27 petition filed by the Department of Agriculture. But I'm sure that many other parties that are going to testify will have their own opinions about the current administration of the overorder premium. So this looks like a extremely interesting set of hearings that are worth attending, and also you're going to hear from many different parties with regard to going on record with their thoughts on the overorder premium and what might be alternatives to it or alternatives to the way it is currently administered. So pretty much everything is on the table as it was drafted by the staff at the PMMB. The evidence will be taken on, in quotes, the existence, level, and duration of Pennsylvania's current overorder premium. So pretty much when you say the word the existence, that means everything's on the table. So that pretty much says it all right there. The entire scope of whether this should be continued and how it should be administered, or should other administrative aspects be incorporated, is all going to be included in there. Also, there was two orders entered. There was an initial order scheduling these 3 days of hearings on August 30th. And then looks like there was some room availability problems, because there was an amended order that moved the hearings to and this is important, they're at the DEP South Central Regional Office on Elmerton Avenue, which is literally right around the corner from the Department of Agriculture and the Farm Show complex, just up the hill a bit from the main intersection where the Farm Show complex is. The Elmerton DEP building is right to your right as you're heading up the hill on Elmerton. In other words, go out Cameron, take a right on Elmerton, and go up the hill, and the DEP is right on your right. Got to figure out how to stop this poll here. There we go. Okay, so that's obviously big news. Just waiting for this. There we go. There we go. On other news, let's go to national issues and USDA and FDA issues with regard to dairy. In May, the Ag Marketing Service, AMS, released a report that's really insightful. It's a report analyzing the milk handled through the federal order system in its totality, and they call it measures of growth in federal orders. Might be called measures in growth, or the lack thereof, in federal orders. And so it analyzed the entirety of 2021 in terms of what milk is going through the system, through the federal order system, and who's participating. And I just literally put in this slide the verbatim summary, which tells it all and is quite insightful, quite interesting, and tells some interesting, a good story here, or an interesting story anyway. Total receipts of milk pooled through the federal order system totaled 136.8 billion pounds, marketed by 23,292 producers. Okay, that's for 2021. Total receipts were 7.7%, in other words, a little less than 1%, lower than in 2020. So pricing wise, comparing those 2 years, not still large numbers, of course, but it's less than 1% off, so to speak, in terms of the value of the milk that went through. The number of producers were down 6.5% from 2020. So you see the obvious trend, which we all know is out there, which is that we have the larger dairies who are producing more milk, and their milk is certainly what's the right way to say it? Their milk is continuing to occupy a larger and incrementally larger share of the total that goes through the federal order system. The average daily delivery of producer milk per pooled producer, so of these total numbers, was 6.4% higher. Another indication of the same thing, which is that the larger and larger dairies. So, and obviously individual producers are pushing through 6.4% higher quantities of milk in 2021. And then this last statistic is the one that really tells the story, which is milk marketed through the federal order system accounted for 61% of all milk sold, and 61% of fluid grade milk sold to U.S. plants and dealers. So, that tells you that, you still have this 39% that is not going through the federal order system. And so very telling report. And I'm sure that those of you who are here, who are a little longer in the tooth in terms of the dairy industry history, may be able to compare that 61% number to past years and decades. But obviously, we've been through a time where depooling is a extremely controversial issue. And I'm assuming that that 61% number is a bit down. If somebody wants to jump in during the Q&A and tell me I'm wrong, that's great. Now, let's talk about exactly what Chloe is going to talk about here, which is plant-based dairy alternatives and how to label them, or is there going to be any direction in the United States with regard to how to label them? And in fact, something is in the works as we speak. On March 30th in this quarter, the Office of Management and Budget, OMB, basically I just call it the White House, it's really part of the administration, received a notice of review, which means something was sent in from the FDA called Labeling of Plant-Based Milk Alternatives and Voluntary Nutritional Statements, Draft Guidance for Industry. That was sent in by FDA for review and then would be issued if approved. So that is now under review by the White House, and it's been under review since March 31st. The text of the actual document that is going to be this labeling guidance for plant-based milk alternatives or dairy substitutes. I like to use that word rather than use the word milk again and confuse people. Plant-based dairy substitute labeling. They have something drafted, but we can't see it. And so we're just going to have to continue to sit and wait. There was a run-up to this process. In September of 2018, FDA published a request for public comments, and there's a citation to that, where people, and there were 12,000 comments. Some of you may have been involved in some of those comments. So a relatively robust dialogue going on there. And, there were specific questions that were asked at that time that were to be commented upon. And so, that set the stage for all of this. Now, and FDA, if you go to this link here where it says FDA stated that the draft guidance is one of a series of actions of FDA over the past 4 years to further regulate standards of identity and plant-based labeling. Well, I guess there's some of us who might dispute that there really has been a series of actions or anything that's been effective in any way. But take a look at that just to get yourself educated as to what exactly it is that FDA is touting as the things that they have done on this particular issue that this is a part of. And perhaps your assessment would be that they have done very little. But the bottom line is, in this process of reviewing this draft guidance, there have been 6 completed stakeholder meetings. And I have listed here in the slide exactly who requested a meeting. And I guess that is this process. And I'm not as familiar with this process as with many other governmental processes. But apparently, when you send something into the OMB for review before you are going to publish it as an executive agency under the president's jurisdiction, there can be stakeholders requesting meetings. Now, when and exactly how much or time they get to spend with the actual document itself in order to prepare for these meetings, I don't know. I don't know whether they show up and they are shown the documents on the spot. The bottom line is we have not seen a leaked copy of this document out there yet, which is a little surprising when at least the groups from these 6 meetings all saw it and got to read it. And you can tell because if you go to the link here for these stakeholder meetings, each one of them has a meeting page devoted to their meeting where all the people that were there are listed and all the documents that were submitted by them are listed. And even in that process, there is one instance where there's a follow-up letter afterwards that clearly gives some hints about what's in it. And because it says, a standard that does this is not going to be acceptable to us or whatever the circumstances may be. And in fact, one of the very clear signals in the documents that in the one sort of after meeting letter that was sent is that the standard appears to indicate that using terms coupling oat with milk or soy with milk under this guidance is not going to be acceptable. So we will see how that goes. Most of the people who requested meetings, of course, are on the pro plant-based dairy substitute side, except for National Milk, I believe, was in there. Yes, it was a law firm requested the meeting on behalf of National Milk. They were the only real sort of dairy side that came. Everybody else looks to be clearly on the plant-based dairy substitute side. The letter, if you look at the meeting from this Good Food Institute, that's the most revealing letter in terms of what might be contained, because that's the after meeting letter where they sort of summarize what they read in there, and then they set it up to rebut it. So that's some interesting stuff. And I was hoping we might get a public release of this before today's webinar. We did not, but we will proceed and hopefully see that in the next months, maybe weeks, hopefully. And we will know where we stand. And then we'll pick up today. Chloe will talk about all of this. All right, a few more things going on. What happened? Wasn't that what I was just, was that in there twice? Yes, it is. Okay, let's talk about little issue that probably slipped under the radar. Just in June, the U.S. District Court of Appeals for the D.C. Circuit, what did I say? U.S. District, excuse me, the U.S. Circuit Court of Appeals for the D.C. Circuit issued an opinion that was essentially a petition for review of the lower court, who had affirmed the FDA's denial of a rulemaking petition to allow the interstate sale of raw or unpasteurized milk. And so that was filed by Mark McAfee from California, who's well known in raw milk circles, and a raw milk producer and seller from California, who operates under California's rules, which do apparently allow intrastate sale of milk, or excuse me, of raw butter. And so long story short, the lower courts, or excuse me, the FDA finally acted on this 2016 petition filed by McAfee and said, no, we're not going to allow the interstate sale of raw milk. And then the lower court, or excuse me, the U.S. District Court in D.C. affirmed that decision, and now the Circuit Court of Appeals for D.C. has affirmed that decision. The bottom line was McAfee's argument was that there was, in establishing the standard of identity for milk, the congressional act that actually enacted that standard of identity, it wasn't by reg in this particular instance, and the history is all right here in this entry. It said that nobody else could establish a standard of identity for milk, and McAfee's argument was that tacking on an interstate sale prohibition was somehow altering the standard of identity for milk. And no court bought that, nor did the FDA. So that's where that stands. This has been sort of hanging around for quite a while. Not to say that, you know, again, nothing potentially against raw butter. And I know that Pennsylvania actually has a petition pending in front of it with regard to permitting raw or butter made from unpasteurized milk. That remains pending. There is dietary guidelines. Talk about dietary guidelines for a second. We've had all of this discussion about whole milk in schools. And of course, the school lunch program gets its guidance, at least on paper, likes to say that it's relying on, excuse me, the dietary guidelines. Let me just get back to the right. Oh, sorry. There we go. Likes to say that it's relying on the dietary guidelines. And so what's the way to get whole milk in the schools? Well, I'm not so sure that these legislative efforts where states are trying to declare something interstate versus intrastate and all of that, and I'm not going to go over that again. I think we did that probably in the last quarter. But the bottom line is the way to get at this probably, or one way to get at this is through the dietary guidelines. And it is very interesting to observe that when you look at dietary guidelines, the word dairy never appears in the dietary guidelines without the words low fat in front of it. And that seems to be an issue that ought to be more on the table. And I know that, for example, Lancaster Farming just did a story about that. And so the bottom line is, and some people would go so far as to call it the demonization of whole milk, and an unjustified, characterization, let's just say, of raw milk as somehow, of whole milk as somehow unhealthy. And so the way to go about that would appear to me to be, or one way would be through the dietary guidelines. So there is now an opportunity to begin to be a public commenter on the dietary guidelines and this issue of whole milk versus non-fat dairy products is ripe for a robust discussion in this next round of dietary guidelines. They're every 5 years. We just did the 2020s dietary guidelines, so it'll be 2025. Okay. In terms of regional actions, there was a federal lawsuit filed in New Mexico by members of DFA and Select Milk Producers, a large co-op out there, essentially claiming that DFA and Select are conspiring to essentially depress members' payments for milk. And not that this is, this is not probably the first time that things of this nature have been alleged, of course. And, it's another in, a series of this type of action where cooperative members are suing their co-op and or multiple co-ops for some type of conspiracy to depress member payment for milk. So this is another in that line. Right now, there is a motion to dismiss pending by all the defendants, and it's still in the briefing stage. I think answers to it were filed, but not briefs yet. So fairly familiar allegations if you plumb the depths of it. So I'll leave that there. The last item I'm going to talk about is just the whole USMCA dispute with Canada. It was a little bit disjointed and odd what happened in the last several months in this quarter. And what happened was that on May 5th, U.S. Trade Representative Catherine Tai met with the Canadian Minister of Trade, Mary Ning, is what I'm going to say. I think that's how you pronounce it. And this was the first meeting of the two of them since the disclosure in early January that in late December, the arbitration panel that was deciding the USMCA dispute between the US and Canada on these tariff rate quota allocations had been released. And of course, that report said that Canada was in fact in violation of the USMCA. And so Canada had proposed, and we don't know exactly how personally any of this was communicated. It was available on the internet as of about March 1, a revision to their tariff rate quota allocation formula. And the issue in a nutshell is simply that the reduced tariff rates for which Canadian operators, we'll qualify that in a minute, would be eligible to bring in US dairy products were only available to processors or further processors. That was determined to be a violation of the USMCA. And so what Canada did as a response to that was they simply added the word distributors. So now it says processors, further processors, and distributors. Well, what the United States wants, of course, is for retailers to be able to purchase U.S. dairy products for resale in Canada. And the problem with processors are they're the direct competitors of those U.S. interests who want to sell into Canada at a non-tariffed rate. In other words, a rate that would make some type of financial sense and that somebody in Canada's side of the border would want to buy it. So now the distributors is added, but not retailers. It's, for the most part, everyone on the US side is completely dissatisfied with that. And the Canadian side thinks that they've complied fully and completely with their obligations under the USMCA. So they went about their business, and on May 25th, the Trade Minister Ning issued a statement saying, well, we've done our part. We've met our obligations. We changed the tariff rate quota allocation system. And so we've actually advertised it on the Canadian side of the border for people to make application if they wish to. And so obviously that does not satisfy the United States interests. So there is another request for consultation, and presumably there'll be another arbitration which will be round 2 of a dispute over the same thing. So the issue really is the finer question of, by adding distributors into the mix, is that improving anything? Is that making anybody on the Canadian side of the border likely to ever apply for these or ever want to import U.S. Dairy products? And I'm sure that these distributors have, already their commitments, with their suppliers on the Canadian side. But I would love to talk in the Q&A about the dynamics there, if anyone wants to jump in. And the bottom line, last thing I'll say is that, interestingly, in all of this process, New Zealand has figured out that they could make the same argument against Canada with regard to their commitments that they have with Canada under the Trans-Pacific Partnership. So they have now filed the same type of request for consultation on the exact same issue against Canada under their TPP agreement. So whether others follow suit, but we know at least one other country essentially done the Me Too thing here and is pursuing the exact same avenue.
Well, thank you, Brook. All right, so first I would like to thank everyone for attending today's webinar. And before we dive into the government efforts currently put into regulating the labeling of plant-based food and beverages as substitute for milk and dairy, I would like to interest you in some economics to help you understand the state and dynamics of the plant-based food and beverage market. All right, so in recent years, I think we all noticed, I'm sure, the timid at first and progressively the mass arrival of plant-based food products on our grocery store shelves. For some of us, these products have even become part of our day-to-day diet. And according to a report issued last year by Bloomberg Intelligence, global retail sales of plant-based food alternatives may reach $162 billion by 2030, or 7.7% of the expected $2.1 trillion global protein market, which they called explosive growth. Their analysts also expect the sales growth for plant-based meat and dairy alternatives to surpass conventional products. The report also points out that plant-based dairy sales are largely comprised of milk alternatives, with plant-based dairy being a mature market, with a market penetration at 10% of the total dairy market, compared to 5% of the total market for plant-based meat and fish. And another interesting finding is that the Asia-Pacific region market for plant-based food products is likely to become one of the largest. The report suggests that the Asia-Pacific region market could reach $64.8 billion by 2030, up from $13.5 billion in 2020, and may lead sales for substitutes to dairy. As for both North American and European markets, they could reach $40 billion by 2030, with Middle East and Africa plant-based market share accounting for $8.2 billion and Latin America $8.8 billion. So this spectacular growth in plant-based product sales is partly due to growing population and scarcity of protein resources. So I have included a link to the report in this PowerPoint, as well as some additional findings if you'd like to learn more. Now, another good read is from a report released by the Boston Consulting Group and Blue Horizon Corporation with similar findings to those in the Bloomberg Intelligence report. They expect that milk and other dairy alternatives will dominate the market, followed by chicken and seafood. And based on the graph you're seeing right now, global consumption of milk alternatives is expected to expand with an anticipated 12% compound annual growth rate for the period from 2025 to 2030, which is forecast to bring the market volume to 35 million metric tons by 2030. However, the fast-growing market for plant-based dairy alternatives had the U.S. dairy industry worried as consumption and sales of fluid milk beverages started to decrease in favor of these plant-based alternatives. According to USDA, there has been a persistent downward trend in U.S. per capita consumption of fluid cow's milk. And the agency confirmed that the rise in sales of plant-based milk alternatives is directly competing with and is a factor in the decrease in sales of dairy milk, even if it represents only a small share of overall sales trends. So the dairy industry and stakeholders have been pushing the Food and Drug Administrations for years to act on the proper labeling of plant-based milk alternatives and preclude plant-based beverages from using dairy terms. One of their major arguments is that plant-based beverage companies, by marketing their plant-based dairy substitutes using the term milk, violate the federal standard of identity for milk and misleads consumers. So first in this presentation, I would like to quickly talk about how FDA currently regulates food standards and how FDA positions itself with regard to the regulation of plant-based dairy products. Second, I would like to give you a rapid overview of litigation activity and address how the argument that using the term milk on plant-based beverages misleads consumers has been viewed by the courts. And finally, I would like to consider the same dairy substitute labeling issue, but this time in Europe. All right, so under the Federal Food, Drug, and Cosmetic Act, the FDA regulates what we call standardized and non-standardized food and beverages. So when going through a product label, the first thing you will read is a statement of identity. In other words, what the product is, which is not to be confused with the brand of a product. A statement of identity must be a name specified by federal law or regulation, or if the law or regulation does not provide for a name, a common or usual name or descriptive term generally used by the public for that type of product. For example, some of you may have consumed Babybel, which is Edam cheese. Babybel is a brand name, but what you can read on its label is cheese made from pasteurized milk. Non-standardized foods must bear the common or usual name of the food. However, in situations where the common or usual name of the food is misleading the public, FDA can establish a new common or usual name by regulation. And under the FDCA, a food is considered misbranded if it purports to be or is represented as a food for which a definition and standard of identity has been prescribed by regulation, unless it conforms to such definition and standards. So now this statement of identity may be subject to, this statement of identity may be subject to standard of identity. And according to FDA, standards of identity were developed to help consumers and ensure that a food product is what the consumer expects it to be. Food or beverages subject to a standard of identity are considered standardized food or beverages. Standards of identity have been established for milk and cream, as well as for cheeses and related cheese products and yogurts. But standards of identity have not been established for plant-based food and beverages and beverage products that are substitutes to dairy, such as milk, yogurt, and cheese, and as a result are considered non-standardized food and beverages. So as I have just mentioned, non-standardized food must bear the common original name of the food. However, when the common original name misleads the public, FDA can establish a new common original name by regulation. But FDA has not done this for plant-based dairy alternative products. So the FDA has never offered guidance addressing the use of dairy terms for plant-based dairy substitutes. However, it did take a position on this issue several times. For example, here on the PowerPoint, you can see in September 1983, FDA wrote a letter to the Singapore Institute of Standards and Industrial Research concerning soy milk and soybean drink. It said, "We have not recognized the term soy milk as a common or usual name or appropriately descriptive term for statements of identity or ingredient designations of any food. As a result, we would object to any soy product entering this country that was labeled as soy milk." And in another letter dated 2008, which served as a warning to live soy, FDA again wrote, "We do not consider soy milk to be an appropriate common or usual name because it does not contain milk. We do consider soy drink or soy beverages, however, as acceptable common or usual names for such products." Later in 2012, FDA used the exact same language in another warning letter, this time sent to Funky Tofu Company. But other than these letters, FDA has been inactive on this issue until very recently, and I will elaborate on that point in a minute. The reason why is not known, and we can only speculate that perhaps FDA has been reluctant to become involved due to the widespread and rapid proliferation of plant-based dairy alternatives on our shelves and the potential for protracted litigation. So as mentioned earlier, the dairy industry primary argument is that using the term milk to market plant-based dairy alternatives violates the federal standard of identity for milk, and as a result misleads consumers. So in the three following cases filed before federal district court in California that I've just listed here on this slide, plaintiffs, all purchasers of different lines of plant-based milk alternative products, alleged that the use of dairy terminology on these products' packaging suggested to consumers that those products were equivalent to dairy milk and thus violated California state labeling law and FDA's standard of identity for milk. Plaintiffs claimed they would have refrained from purchasing these plant-based alternative products had they known the products were not comparable in terms of quality, taste, or nutritional benefits to actual dairy products. In the Gibson and Eng cases, plaintiffs also stressed that FDA 2008 and 2012 warning letters reflect the position of FDA on the misuse of names of standardized dairy products and should act as guidelines. So all defendants in these three cases counter-argued that plaintiffs' claims are implausible as a matter of law because a reasonable consumer could not be deceived into believing that any sort of plant-based milk alternatives has the same lacteal properties than dairy milk. They also argued that plaintiffs' state law claims are preempted under the FDCA because they erroneously relied on FDA warning letters to interpret FDA labeling rules and regulations. And as a result, plaintiffs' state law claims are based on alleged violations. But in the alternative, defendants argued that these cases should be dismissed or stayed under the primary jurisdiction doctrine, and that the ambiguities related to the standard of identity for milk should be addressed by FDA itself. And in their final decision, that's the good slide. In their final decisions, the district courts all agreed with the defendants that plaintiffs' state law claims are preempted by the FDCA. The court clarified that the standardization of milk simply means that a company cannot pass off a product as milk if it does not meet the regulatory definition of milk. However, in these cases, defendants did not call their products milk, but instead called them soy milk or almond milk, and those properly conveyed the basic nature and content of the beverages while clearly distinguishing them from dairy milk. The district courts also dismissed plaintiffs' arguments that FDA warning letters should act as guidelines and found that even the least sophisticated consumer would not mistake a substitute dairy product like soy milk or almond milk with dairy milk, and stated that if anything, people choose to drink plant-based milk because it is not dairy milk. So the district courts dismissed all three cases, but in the Painter case, plaintiffs filed an appeal with the Ninth Circuit Court of Appeals, which decided to affirm the district court's judgment. Here I also have listed two additional cases also filed in federal district courts in California with similar facts and arguments raised, but where the district courts found that plaintiffs' claims fall within FDA's primary jurisdiction and decided to stay the case pending appropriate administrative actions before the FDA. And finally, in another case, Miyoko's Kitchen versus Ross, this time dealing with plant-based butter, a federal district court in California ruled that Miyoko's Kitchen, a plant-based dairy food producer, could use dairy terms like butter to describe its vegan product on packaging. Just as a little bit of background, in December 2019, the California Department of Food and Agriculture asked Miyoko's to review its label cultured vegan plain butter to comply with federal and state regulations because the product was not butter as per the federal definition of butter. The State Department said that the product was misleading to the public. And in addition to the term butter, claims such as lactose-free, hormone-free, and cruelty-free, as well as a picture representing a woman hugging a cow, figured on the packaging, and the department requested that Miyoko's remove these claims and picture from the label, as it unfairly implies that a product can only be dairy food without these claims. And the label also read revolutionizing dairy with plants, and the State Department also wanted that claim removed because the product at issue is made entirely of plant oils and does not originate from an animal. In February 2020, Miyoko's filed a lawsuit against the State Department under the U.S. Constitution's First Amendment, challenging the regulatory authority of the state and arguing that such action does suppress freedom of speech and in no way does provide any service to the public against deception. On the other hand, the state argued that the federal definition of butter, which has been enacted since 1923, is reflective of what consumers believe is butter. So the court agreed in part with Miyoko's and held that, quite simply, language evolves and rejected that the 90 years old federal definition bears heavily on consumers' understanding of butter. And for that, the court ruled that the state cannot restrict Miyoko's use of the terms butter, lactose-free, cruelty-free, and revolutionizing dairy with plants on the product label. However, the court sided with the state as to the use of the claim hormone-free, as it is not constitutionally protected commercial speech. So one thing I want to make clear here is that these federal cases do not constitute precedent outside of the federal district courts of California. However, they can be a good indication as to how potentially other courts could interpret FDA standard of identity for milk and other dairy products. So in September 2018, FDA issued a notice in the Federal Register seeking comments on the labeling of plant-based products with names that include the names of dairy foods, such as milk, cultured milk, yogurt, and cheese. The reason of this request was for FDA to learn how consumers use and consider plant-based foods and how they perceive terms like milk and yogurt when in combination with the names of plant-based products. More specifically, FDA sought comment on the current market conditions and labeling cost of plant-based products, on the consumer's understanding of the characteristics and physical properties of plant-based foods and consumer understanding of the nutritional values of plant-based products and dairy products and its effect on consumer purchasing and consumption behavior, as well as the role of plant-based products and dairy foods in meeting the recommendations in the government dietary guidelines. So the public comment period closed in January 2019, and as Brook mentioned, FDA received approximately 12,000 comments. So not much else happened until January 2022, when FDA announced that it intended to provide guidance next year on the labeling of plant-based milk alternatives and animal-derived foods. And again, on March 31st, 2022, the Office of Management and Budget, OMB, received a notice for review from FDA, which means a draft of FDA guidance is now pending and under review for potential publication. And also, just like Brook mentioned, unfortunately for us, the text of the rule has not yet been published or made public. However, the OMB has conducted 6 stakeholder meetings, and following a meeting with the Good Food Institute on May 23rd, 2022, a follow-up letter was sent to FDA by the Institute. And from that letter, it can be inferred that FDA is recommending special nutrient statements that would only apply to plant-based products using milk in their names, and may also prevent non-dairy milk producers from using the term milk on their packaging. For example, the name soy milk or almond milk will not be allowed to describe the product on packaging. FDA would also require plant-based food companies to change their labels for new and existing products with special labeling restrictions. So some have raised concerns that such labeling changes would turn out very costly for the plant-based food industry. In the meantime, 4 members of the US Congress sent a letter in May 2022 requesting the OMB to return the draft guidance to FDA. They wrote the OMB that any guidance, even if voluntary, that asks plant-based milks to identify differences without doing the same for animal milk is discriminatory towards the plant-based industry, as well as the hardworking farmers who grow crops like oats and almonds. FDA should not be using its labeling authority to harm a growing industry and the millions of American consumers for whom plant-based foods are an important part of their diet. And as a result, if this draft guidance contains any such provisions, we urge you to return it to the FDA without moving forward. All right, so before we finish today's presentation, I would like to discuss the way the European Union has been dealing with the same issue and how it could potentially influence the United States. So in the European Union, meat and dairy terms have already been prohibited from appearing on packaging of plant-based or substitute meat and dairy products, following the adoption of Regulation number 1308 in 2013. For dairy products, the regulation clarifies what terms are to be exclusively used for the designations of milk and milk products. So point 1 of the regulation describes the term milk as meaning exclusively the normal mammary secretion obtained from one or more milkings without either addition thereto or extraction therefrom. Point 2 describes milk products as derived exclusively from milk and containing its constituents. The regulation provides in subparagraph A what terms must be reserved exclusively for milk products at all stages of marketing. I'm sorry for the slides. At all stages of marketing, and these terms include but are not restricted to wheat, cream, butter, buttermilk, cheese, and yogurt. So the term milk cannot be used to designate a purely plant-based product, and the terms whey, cream, butter, cheese, and yogurt cannot be used to designate a purely plant-based product. Now, point 4 of the regulation states that the origin of the animal species from which the milk originates must be documented if it is not coming from a cow. Point 5 provides that the names referred to in point 1 and 2 may not be used for any product other than those referred to in the regulation. However, it provides that this restriction on the use of the term milk and dairy terms for milk products do not apply to traditional designations of products or designation describing the specific feature or quality of a product. The European Commission provides a list of exceptions that I have listed underneath the regulation on the slide, where the use of the term milk or dairy terms for milk products are allowed with an additional term. So peanut butter, coconut milk, cream of tartare, or cocoa butter are listed as exceptions. However, soy, almond, oat, or tofu are not part of the Commission list. And a few years ago, the European Agricultural Committee introduced Amendment 171 before the European Parliament as part of the revision of Regulation 1308, which amendment has been debated as part of a reform of the European Union Common Agricultural Policy for 2023-2027. One of the objectives of this reform was to align the Common Agricultural Policy with the European Green Deal and farm-to-fork and biodiversity strategies. So the European Parliament received a lot of backlash and pressure from environmental and consumer groups, as well as members of the European Parliament, to oppose Amendment 171. These groups pointed out the inconsistency between Amendment 171 and the European agenda for a more sustainable and healthy diet as part of its farm-to-fork strategy. Indeed, Amendment 171 would have more severely restricted plant-based dairy substitutes to dairy, and provided that the designation used for milk and milk products should be protected from any direct or indirect commercial use of the designation, first for comparable products or products presented as capable of being substituted not complying with the corresponding definition, B, insofar as such use exploits the reputation associated with the designation. So in other words, Amendment 171 would have prohibited plant-based food and beverage companies from using representations or packaging that so closely resembles traditional dairy product that the plant-based dairy substitute would be commercially benefiting from the resemblance. Subparagraph B also provided that these designations should be protected from any misuse, imitation, or evocation, even if the composition or true nature of the product or service is indicated and accompanied by expressions such as style, imitation, flavor, substitute, and so on. Basically, would have prohibited any form of comparison to their dairy counterparts. And finally, subparagraph C would have prohibited any other commercial indication or practice likely to mislead the consumer as to the product's true nature or composition. In other words, plant-based food and beverage companies would have not been able to include certain kinds of health information like allergen labeling information, like does not contain milk or lactose-free milk alternative, for example, or certain descriptive terms such as creamy or cooking cream. And the second paragraph of point 5, however, would not have changed. So under pressure, the European Parliament withdrew Amendment 171 from its reform negotiations without further explanation, which was a big victory for these groups and put a temporary stop to the debates. And I say temporary here because discussions surrounding the use of meat and dairy terms are still very much heated and or even nationally debated in member states. For instance, the French government recently published a law in late June that will prohibit the use of meat terminology such as bacon, burger, nugget, steaks, etc. to describe plant-based meat products. Many French NGOs and environmental groups regretted the government decision that they considered conservative and contrary to European politics and present world challenges. And this law is set to become effective in France this coming October. So now to wrap up this presentation, we can ask ourselves when FDA guidance will come out, whether they created a labeling system that is going to go as far as Amendment 171, or if they will have crafted something more like Regulation 1308 that is currently in place in Europe. And once FDA issued this guidance, we will make sure to keep you informed. All right, so that's it for today. Thank you all for your attention.